This is the first piece of the puzzle, divorce law and how it relates to real estate. Under the divorce law topic, we are going to take a look at separate versus marital property, as well as various means and ways to distribute real estate. Generally, there are three basic questions divorcing clients ask when deciding to get a divorce. 1, what is our property? 2, what is it worth? And 3, how are we going to divide it? After answering these three questions, the obvious first step is to determine what portion of the equity is marital and what is non-marital. State laws vary broadly on this issue. Property must be identified as marital or non-marital before distributing in a divorce proceeding. Let's take a closer look at the difference between separate and marital property before we look at some of the common mistakes made when distributing real estate assets. Separate or non-marital property is deemed not to be part of the marital estate and is therefore assigned to the owner or spouse prior to the division or allocation of the marital estate. The party seeking to have property treated as non-marital has the burden of proving that he or she owned it before the marriage or received it during the marriage as a gift or inheritance. Separate property is any asset acquired before the marriage. Now, if the asset was encumbered by a loan that was paid off during the marriage, it may only have partial non-marital value. The two most common forms of the marital property are those acquired by gift, legacy, or descent prior to or during the marriage, or before the marriage and not transferred into co-ownership with the spouse. Other sources of non-marital property can include prenuptial exclusions, an asset excluded by a valid prenuptial agreement, personal injury proceeds. Personal injury settlements are generally considered personal to the injured party and are non-marital in nature. Inheritance, any proceeds or assets from an inheritance, or gifts, any asset required as a gift to one but not both parties.